Drug trafficking in South Carolina. When you think of drug trafficking, you typically think of someone smuggling large amounts of illegal narcotics across state lines or even international borders. Make no mistake, that does happen, but under South Carolina's statute, you can be charged with drug trafficking for merely being in possession of a certain threshold weight or amount of illegal narcotics. You don't need to be transporting the drugs anywhere, and in some cases, you don't even need to be in possession of the drugs at all. If you provided financial assistance, provided aid, or if you conspired with another person to be in possession of a certain threshold weight or amount of drugs, that's enough for the state to bring a charge for drug trafficking here. Hi, my name's Dale Savage and I'm a criminal defense attorney here in Charleston, South Carolina. And today we're going to talk about the drug trafficking laws in this state. Drug trafficking laws in this state can be tough because you can be charged based on possession of a certain threshold amount of drugs or weight, or you can be charged if you conspired or provided financial aid or assisted someone to possess a certain amount of illegal drugs or weight in this state. So how is drug trafficking defined in the state of South Carolina? To do this, the prosecutor must show that you knowingly sold, manufactured, or tried to bring into this state a certain threshold amount or weight of illegal narcotics, or that you provided financial assistance or aided someone or conspired with another person to be in possession of a certain threshold amount or weight of illegal narcotics in this state. And lastly, if you are caught in possession of a certain threshold weight or amount of illegal narcotics. Trafficking cases typically fall into two categories where law enforcement will make their case. The first is when you are in possession of the threshold weight or amount required under the statute. And the second is where you provide financial assistance, aid, or conspire with another person or persons in an attempt to be in possession of that threshold weight or amount. So what is the threshold amount that we're talking about? Well, it depends on the substance that you're talking about. The statute provides different weight levels or amounts for different types of illegal narcotics. When we're talking about marijuana, the minimum threshold weight to get into the trafficking level offense is 10 pounds and above. When it comes to cocaine or cocaine mixtures, the minimum amount is 10 grams or more. And the same amount comes in for meth. It has to be 10 grams or more to be trafficking meth. Now, when it comes to ecstasy or MDMA, it has to be 100 dosages or more to meet the threshold level for trafficking. And when it comes to heroin, you only need to have 4 grams or more to satisfy the threshold weight for trafficking in South Carolina. So what that means is if you are caught in possession with that minimum threshold level of narcotics, the state doesn't need to show anything more. The statute, by the sheer weight of the drugs or the amount of drugs that you have in your possession, is presumed that you're a drug dealer. They don't have to provide any other evidence showing that you attempted to sell or were trying to sell the drugs to anyone. The mere fact that you had that quantity in your possession meets the definition for trafficking in this state. So what are the defenses available when you're taking on one of these types of cases? Your defense typically falls under one of two categories. First is any challenges under the Fourth Amendment, which basically means any unreasonable search or seizures. And the second has to do with conspiracy cases where you're dealing with wiretaps typically. When we're talking about Fourth Amendment issues, it usually comes up in one of two categories: traffic stops or a search of your home or apartment where you're residing. When it comes to traffic stops, you need to review whether the police had probable cause to search your person or your vehicle where the drugs were located. And remember, this is typically a warrantless search, and so it's a fact-intensive investigation that needs to be viewed from the beginning of the stop till the time that the police located the narcotics in your vehicle. When it comes to searches of your homes or apartment, again, did police have a warrant to search that location? And if they did, was that warrant lawful in the first place? Now, when it comes to wiretap cases, the same sort of analysis goes with that. Did police have the appropriate authority, meaning was the wiretap lawful? Did a judge sign off giving them authority to conduct that wiretap of your phone? Secondly, if they did, what's the basis of the conversation? Typically, people dealing in narcotics don't talk plainly when they're talking about transactions. A lot of the times they can use code, and it's up to sometimes the interpretation of what those codes mean. If you're talking about one or two conversations, sometimes that can be difficult to prove that case. Now, if you're talking about dozens and dozens of calls that talk about weight, price, and those types of things, even if it's in code, that can make the case certainly a lot tougher. And so those wiretaps need to be reviewed and analyzed to see what strength the state's case is or isn't in your particular circumstance. So if you've been charged with drug trafficking in South Carolina, please give me a call at 843-530-7813. I hope this video was helpful, and thanks for watching.